The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Five cases will be submitted this afternoon. Those cases are State of Iowa versus Demetrius Rimmer, State of Iowa versus Rona Murphy, State of Iowa versus Melonicka Thomas. Those cases are consolidated for the purposes of argument this afternoon. The next case is State of Iowa versus Adam Christopher Dahl, and the final case is David Lowell Evenson versus Winnebago Industries, Inc. and Century Insurance Company. This last case is now submitted to the court without oral argument, and we'll now hear the arguments in the first three consolidated cases. Ms. Reddy, you may proceed.
May it please the court, counsel. My name is Vidhya Reddy, and I am appellate counsel for defendant Demetrius Rimmer. Jack Dustemer, who is appellate counsel for co-defendant Melonicka Thomas, is also here. Our plan today is that I will primarily present argument. However, Mr. Dustemer will be available if this court has any questions for him, or if we have time remaining, he may make some comments as well. In this state's appeal, the sole basis for Iowa's exercise of criminal territorial jurisdiction over these defendants, none of whom were ever within the state of Iowa, is that the defendant's allegedly fraudulent insurance claim was routed by the Wisconsin Insurance Company's parent corporation, Century, through a claims office within Davenport, Iowa, so that unbeknownst to any of the defendants, the statements that they made while located outside of Iowa were ultimately heard by a claims processor that was located within the state of Iowa. This court on appeal should hold that the district court acted properly in dismissing the prosecution for lack of Iowa criminal territorial jurisdiction, because jurisdiction does not conferred either under the language of the jurisdictional statute, because none of the essential elements of the offense were committed within this state. Additionally, this court should hold that exercise of Iowa criminal jurisdiction in a case such as this, where none of the defendants either knew or had reason to know that their conduct was affecting Iowa, would violate state and federal constitutional principles.
Counsel, wasn't the crime committed in part in Iowa, if you consider the phone call from Illinois to Iowa, because they're making fraudulent statements to somebody who's in Iowa? Doesn't that satisfy the statute?
So that's the state's position, that those telephonic statements amounted to conduct in Iowa because they were ultimately heard or perceived here. Defendant's position is no, that does not mean that any of the elements were committed in Iowa, because it's not conduct in Iowa. Admittedly, jurisdictions are not entirely consistent on whether they determine that telephonic contacts are conduct only where the defendant is located when uttering the words, or whether they're also conduct where the other participant to the phone call is located when perceiving the words. However, the cases cited in the defendant's materials do hold to the position that it's conduct only where the defendant is located. In addition to those cases, I would also bring to the court's attention the Illinois appellate court case, People v. Baker, which is actually cited in the state's materials. But that case also holds that conduct by, that telephonic statements made by the defendant is conduct only where the defendant is located, and is not conduct where the recipient is. In that case, the court did find jurisdiction on another ground, but in terms of whether it's conduct within the state, they said it did not qualify.
I'm troubled by that, and I recognize there's a split in authority in cases going both ways on when the defendant is outside the jurisdiction and there's a phone call. But if I'm worried about setting a precedent where somebody could swindle Iowans over the phone or through cybercrime and be safe in some other state and free of criminal charges here, even if they victimized an Iowan.
Sure. So I think there might be some basis for drawing a distinction between cases where a defendant is purposely directing their communications within to a state. I think in that case, maybe there is more of a basis for saying they're transmitting their conduct into the state because they're doing it knowingly, whereas in a case like this where the defendants don't know that they're in any way contacting the state, our understanding of conduct should be limited to the behavior of the defendant.
This knowingly requirement sort of bothers me, because what if they're making these robocalls and unknowingly gets an Iowa resident, and the Iowa resident sends a check? I mean, and really the basis of my question is, if Safeco sent a check from Iowa rather than from Wisconsin, would it be a different result?
I think arguably it could, because particularly if the definition of the, and I'm assuming we're talking about criminal jurisdiction still,
criminal jurisdiction. If someone makes a robocall, gets someone up in Fort Dodge, Iowa, and says, we got this great deal, we got this bridge in Brooklyn and you want to get out on the ground level, and then someone actually sends a check. Not that all Fort Dodge people would do it cheap, but and then they send the check. I mean, it seems to me maybe if Safeco sent the check here, it might be different, and that might be the gatekeeper on this thing.
I think if the detrimental harm that results from the crime and is part of the definition of the crime, sending the check or receiving the check or anything like that occurs within the state, that can provide an independent basis. Additionally, it's not necessarily limited to just actual knowledge. That's not the standard that the defendants propose. We acknowledge that if there is reason to know that the contact is with the prosecuting state, that could be enough to put the defendants on notice so that prosecution could be held within that state.
Let's pursue that reasonable notice business. When you have an automobile claim, you can call your local agent if you want, but it's reasonable to assume that it's going to be handled by claims someplace. Now, if I understand the record right, there's no showing that when the claims process began that they knew exactly that it was in Davenport. But didn't they have a reasonable suspicion that it was going to be handled in some other jurisdiction? Insurance claims are kind of located in claims locations throughout the country. So although they may not have known specifically of Iowa and Davenport, but is it that unfair to say, well, you knew that it was going to have extraterritorial effect and the due process is not offended when criminal jurisdiction is imposed under those circumstances?
I still don't think it's appropriate to impose criminal jurisdiction in that circumstance, and that's because of the due process understanding that there has to be some kind of notice of the particular criminal statute or criminal law that's going to be invoked. And although we have general understanding that in this globalized world, maybe that when we engage in a transaction, that transaction is maybe processed through.
What about the fact that this was initiated by using a 1-800 number?
That's right, and I think that further demonstrates that there was no reason to know that it was Iowa that they were affecting. I think it also bears noting that.
Are you trying to tell us that no state would? There's some state or some jurisdiction that would say this was legal and it wasn't a crime?
And the state makes that point that fraud is fraud everywhere and is presumably prohibited in all 50 states.
This kind of fraud where you have a false insurance claim, this is not like a technical fraud. This is a a real fraud,
Sure.
as we say.
But the principles that are articulated as to jurisdiction have to apply to all crimes, right? Even ones where, in all circumstances, even ones where possibly there isn't a crime committed or it's inadvertent or something like that.
Do any of the defendants offer a location where jurisdiction would be?
No, Your Honor. My point is that when we're looking at due process requirements, we don't say that it doesn't matter if a statute prohibited the conduct, or it doesn't matter if the statute gave notice of the conduct that was prohibited because defendants should have known that it was wrong, or defendants, it was improper anyway. So that's one point. Additionally, while it may be true that fraud is illegal in all 50 of the states, that doesn't mean that it's defined in the same way. That doesn't mean that it's subject to the same penalties, and it doesn't mean that the degree of overlapping crimes that apply to the alleged fraud are the same in all 50 states. For example, here there are 5 crimes charged on this this allegedly fraudulent claim, and that's not necessarily the case everywhere. So I think that does bear significance, that even if it might be a crime in multiple jurisdictions, it's not defined the same way or punished in the same way.
So the staged accident was in Chicago, and the briefs state that Illinois did not prosecute. Does the record show why they didn't?
No, it doesn't.
Were they charged in Wisconsin?
Not as far as the record demonstrates, no. So one of the defendants was in Wisconsin. The others were in Illinois. The initial claim was made while they were in Illinois, and then the rest of these statements.
And the only time they've been in Iowa is when they were brought handcuffed.
Correct.
After being extradited.
Correct.
Now, at one point in the phone calls, a 563, a Davenport area code was provided to Defendant Murphy. Does that put him on notice?
I don't believe that was in the do you believe that was in the record, Your Honor?
I may be mistaken, but I thought it came a call back and the Davenport adjuster, without mentioning he's in Iowa, gave a 563 area code as a number to call back.
Okay, and that may be true. Perhaps the state can point us to that. I didn't see that in my review of the record. I don't think an area code would probably give notice. Maybe that it was not in the particular in their area code, but not necessarily that they would have reason to know that it was in Iowa.
What about the Court of Appeals view that although they may not have known what state, they knew they were defrauding somebody somewhere in a state, and wherever that happens to be, they're running the risk of being crime there?
So my response to that is simply that that's really not any sort of that contravenes the reality that there are constitutional restraints on the exercise of jurisdiction, because that would effectively mean that if a crime is committed anywhere within the state, any other state can prosecute that crime, can reach that crime. So that's really not a limitation at all. And again, due process requires notice of the particular state that seeks to exercise jurisdiction. Another point I'd make is that as the notion of jurisdiction has changed over time, so that we can now have concurrent jurisdiction with multiple states prosecuting a particular offense. I think that's an important reality that is important to keep in mind when determining what requirements exist for a state to exercise criminal territorial jurisdiction, because we know that double jeopardy principles, for example, don't prohibit separate sovereigns from prosecuting a single crime. So, theoretically, Wisconsin, Illinois, and if Iowa exercises jurisdiction, Iowa and federal courts could all prosecute these defendants. And so I think, particularly in light of that, it's important that whenever jurisdiction is exercised, it's by a state or a governmental body that has a sufficient interest, sufficient nexus to the crime that has allegedly been committed. I would also like to touch briefly on, the state makes the point in its resistance to the further review application, and I believe the state maybe takes the position that there really are no constitutional limitations on jurisdiction, and the cases cited in defendants' materials, I think, contravene that. But the state also argues that this is really, that the defendant's complaint is really a choice of law type complaint and not a jurisdiction complaint. And they point out that in the civil context, a court can exercise jurisdiction but then apply the law of a different state if that is what's appropriate. But importantly, in the context of substantive criminal law, we don't have that option of doing that. Jurisdiction and choice of law are and have to be one and the same. So Iowa cannot assert jurisdiction over these alleged crimes and then apply Illinois or Wisconsin law. And so again, I think that's another important point that this court should keep in mind when deciding this question.
To what extent should we look to civil personal jurisdiction cases with the minimum contacts test as guidance? I mean, if the civil standard, the jurisdiction would be lacking in a civil case, does that mean it'd be lacking in a criminal case?
So I see I'm out of time. May I briefly respond? So a defendant's position is it's not an exact transplant of minimum contacts analysis, in that we don't say that if there are lots and lots of general contacts over a defendant that we can always apply our criminal. So for example, if the defendant was a resident of Iowa but committed the crime in Maine, that we get to exercise our criminal territorial jurisdiction just because of that. But the underlying minimum contacts analysis is our due process concerns about foreseeability, about notice, and that is what we believe needs to be transplanted into the criminal context. Thank you.
Thank you, Counsel. Ms. Link?
May it please the court. There are two distinct issues before the court today. Obviously, one is the statutory interpretation question. And because that's a necessary predicate to even reaching the constitutional question, I want to address that first. The question properly presented today is whether the Iowa legislature, in its power, in its jurisdiction, has in fact, by statute, exercised that power to apply its criminal laws to the fraudulent criminal offenses committed by these defendants. And the answer to that is clearly yes. We looked at section 803.1, which tells us exactly when the legislature believes its criminal laws should apply to a case. And we know that whether it is a conduct element, which encompasses both actus reus and mens rea elements, or a results element, that occurs in Iowa, the legislature believes that our criminal laws should apply. Because we define jurisdiction by reference to the elements of the statutes, we look to those particular elements in this case. Now, as counsel has already explained, there are 5 offenses charged equally against all 3 defendants. With the 3, what I'll call the substantive offenses, fraudulent practices, fraudulent submissions, and theft by deception, the key elements that we look at that we see as the most relevant in establishing jurisdiction are knowingly executing and tendering a false certification or affidavit to the insurance claims handlers in Iowa, presenting a written document or oral statement with false information to those insurance claims handlers, and creating or confirming a belief as to false facts, again, to the insurance claims handlers in Iowa.
Well, okay, so it's undisputed, of course, that the claims were handled in Iowa, but you heard the discussion back and forth about kind of what did they know and when did they know it. It seems that they had no reason to know that the contacts were in Iowa, at least to begin with. Now maybe, and I'd like you to clarify what the record states. If you have some callback numbers, and if you knew it was a 563 area code, arguably that puts you on a little more notice. But at least up until that time, I think it's fair to say that they had no idea that they were talking to somebody in Iowa. Now, maybe pursuant to my earlier question, they were talking to somebody, and maybe it was extraterritorial from where they were, but they really didn't know it was Iowa. And certainly under our civil jurisdiction, that would be a kind of a relevant factor. Why wouldn't it be relevant here?
Well, so I think there are two questions. One, the state of the record.
Probably three questions, but go ahead.
Sure. So the state of the record first, because I noticed the area code. I will be honest, I didn't see the actual area code in the minutes. The minutes are pretty extensive and not particularly well organized, so it is possible that you saw something that I did not. We do know that multiple phone calls were exchanged, there were callbacks, and there was a fax. So obviously we could figure out what the fax number was. I do not believe that's in the record, but we do know that Defendant Rimmer faxed, I think, a receipt for towing company to Greg Perrin in Iowa. With regard to knowledge and the role of civil personal jurisdiction, which is what they're really invoking here, that is completely an opposite for many reasons. First of all, minimum contacts and the references there to sort of purposely availing yourself of a particular jurisdiction's laws is all about the power of the court to render a particular person subject to their judgment, a default judgment. That question in criminal law is answered purely by presence. Because of that, in many ways, it's more protective. There are no default judgments in a criminal prosecution, nor are there trials in absentia. We can kidnap the defendants, hogtie them, and throw them into court, and this court has jurisdiction under the criminal law to render that verdict. So there is no parallel in civil personal jurisdiction for that issue.
Then if they run away, you can try them in absentia, right?
I think we generally try not to do that.
Strike me, because I think maybe like some other members on the court, I don't have a lot of familiarity with criminal personal jurisdiction, but I know something about civil personal jurisdiction. It does strike me it would be difficult for, let's say, Century had paid the claims for Century to bring a lawsuit in the state of Iowa against these individuals to get the money back. Wouldn't you agree with me?
So, Your Honor, in contrary to your position, I have very little civil litigation experience, and certainly we have not briefed or gone through what minimum contacts
Must have taken it in law school, right?
No. Whatever I studied for the bar exam is the limit of my knowledge. So with regard to that, however, first of all, we simply know under U.S. Supreme Court precedent that has been recognized in this court, that is just not applicable. We don't apply that. It's never been applied in a criminal context. Moreover, and I think when you look to international issue, which is what we look to predominantly when we look at the reasoning and rationale for even developing the minimum contacts test, it's rooted in due process balancing, looking to Matthews v. Eldridge. The criminal law uses due process in a very, very different way because due process is much more protective of criminal defendants. Because due process, or what process is due, as well as what notice is due, is defined predominantly by the 4th, 5th, and 6th Amendments and an abundance of Supreme Court case law, to technically make out a new due process claim that is not already recognized by our courts, you have to meet a much different standard of fundamental fairness or offending our typical traditional notions of justice.
Well, maybe, but the criminal power of the state is as awesome as it gets. We can incarcerate you for long periods of time. Before that awesome power is exercised, there's got to be at least some element of fundamental fairness in the reach of the state. I mean, maybe it's a different test of some kind, and you know, I think it's fair to say in civil jurisdictional analysis there can be jurisdiction in multiple places and so forth, and we don't ordinarily have that in the criminal law. But before this powerful arm of the state reaches out and grabs a defendant under threat of incarceration, there's got to be some kind of underlying predicate more than kind of a mere flash, it seems to me. I mean, there's at some point the state has a burden of showing that awesome power is triggered. You surely agree with that much. And then the question is, do these phone calls, are they sufficient to trigger this power?
Well, so I have a couple different responses. I don't know how you're going to like them. But first of all, I mean, when it comes to actual precedent in this country, federal constitutional precedent, no, we actually do not have precedent that suggests that the Constitution necessarily limits the state's power. Whatever limit it may have has been left at a sort of theoretical, hypothetical level. It has not actually been found in any case that I have seen. No states exercise.
But don't you agree it just really seems anomalous that the standard would be lower in a criminal case than it would be in a civil case for the state to exercise that power?
Well, again, Your Honor, I think that the standard is actually higher because we have great protections. So one of those things, when we look at what process is due, that's not going to vary much because the U.S. Constitution applies equally to all jurisdictions, and there are great safeguards provided to criminal defendants anywhere that they are tried. But again, the question here is not the power of this court to be the court that oversees the criminal trial. The question is whether Iowa's laws apply. And even in the civil law arena, the question of what law applies is a conflict of law question, and the U.S. Supreme Court has said multiple times that they do not use or import the minimum contacts test. And when you look at, as I understand it, from, for example, Allstate, you look at simply a state's interest in having its law applied. Obviously, as the Court of Appeals found here, Iowa has a great deal of interest in applying its criminal laws to protect residents and businesses in the state from criminal activity.
Is there any evidence in the record or anything in the record that Safeco was shopping this case around with the various criminal, authorities in the different states?
How do you mean exactly?
Well, going to the Illinois State's Attorney's Office, going to the County Attorney in Wisconsin, going to the County Attorney in Iowa, because, this is not a crime where you'd get notice of it. You'd had to be referred by somebody. And is there any evidence of how these crimes got to the County Attorney or the State's Attorney in Illinois or the County Attorney in Madison?
Well, I can't speak to, there is nothing in the official record of what conversations would have happened in Wisconsin and Illinois. I know that here, so they are accused of being part of a pretty broad-ranging insurance conspiracy. Here, Century Insurance claims handlers in Davenport, Iowa are the first ones that actually caught on to it, and they called the Davenport police, I think that's in the minutes, and basically reported it and said we've been
Under your theory
defrauded.
of jurisdiction, how many places can these people be charged?
With what I can see.
With a fraud, let's assume the fraud law is the same in Illinois, Wisconsin, and in the federal system. I mean, could they be charged on all four?
I do not. So I think that actually depends on the particular offense. So, for example, fraud offenses do not, in Iowa, and I do not believe in Wisconsin because I did look at their statute, require that you obtain money. It's really just the conveyance of false information. From the minutes I see, no false information was provided to people in Wisconsin. So potentially the Wisconsin resident making phone calls there, if Wisconsin's jurisdictional statute provided for that, could exercise jurisdiction. Illinois could probably exercise jurisdiction, certainly, over its residents if they consider the act having occurred there.
The federal government, because it occurred across state lines?
If they have a statute providing for that particular crime. And
they have mail fraud or wire fraud. I mean,
yeah,
almost be charged with anything under the federal statute.
Certainly, and there is no law that I've ever seen that suggests that concurrent jurisdiction in criminal cases is a constitutional problem. There's simply no support for that, and that is simply part of what you accept as the consequences of your criminal conduct. If you are going to commit a wide-ranging conspiracy across multiple jurisdictions.
Would you agree that there's no Iowa victim to this crime?
No, I would absolutely disagree with that.
So who's the Iowa victim?
Well, first of all, victim is not an element of the offense, so I do not suggest that the presence of the victim by itself confers jurisdiction. I think it's the occurrence of an element. Okay. But here, the fraud was received. The beliefs were created in the insurance handlers in Davenport, Iowa, who are directly responsible for determining how much money to pay out.
Who suffered the financial harm?
I'm not sure how much money was actually paid out, but financial harm, again, is not an element particularly of the fraud offenses and has no basis in our jurisdictional analysis because that is governed by statute and not by common law here.
Okay. Does it make a difference that it was just a Wisconsin insurance company paying money out through a Wisconsin bank account, that's where the financial loss in whatever amount occurred rather than Iowa?
No, again, I realize that this is something that it is common to look at in civil cases and in minimum context, but here we're looking at the elements of a criminal offense and financial loss and the presence of the victim who is not a party to this. The corporation is not a party to this lawsuit. This is a lawsuit between the state of Iowa, who are prosecuting defendants for engaging in criminal behavior against the public, the Iowa public. That is what we do. That is what they are accused of. I also want to return a little bit to the concept of notice and knowledge under the due process. We've talked a little bit about how we know what process is due differently in the criminal process. But when we talk about notice, what it's fair to know, we want you to know that your conduct is criminal. That is the notice that we care about under due process. We don't ask, for example, if you have a Greyhound bus traveling across the country and in the middle of the night, one of the passengers is really sick of the guy next to him snoring and he kills him. We don't say when they stop the bus and the police come, oh, did you know that you were murdering him when the Greyhound bus was passing through Texas where there happens to be the death penalty? Oh, you meant to murder him before we got to Texas so there would be no death penalty? No, we don't ask that. That's essentially saying mistake of fact, which if that does not negate an element of the crime is not a defense at criminal law. We care that the defendants know they were engaging in criminal behavior. And there's no argument here that they intended to commit fraud. They intended to commit it in Wisconsin, in Illinois, and whoever they were talking to when they called a 1-800 number. The fact that they actually committed that in Iowa is not a defense. There is certainly no constitutional precedent for striking down jurisdiction in this matter.
You know, Iowa has that escape case where the Iowa prisoner being transported to, was it New Mexico? He escapes in Texas, and we held there was no territorial jurisdiction to prosecute him here. So you have to rely on the fact that the phone call from Illinois or Wisconsin to Iowa was the crime committed in Iowa, right?
Yes, I'm out of time if I may respond. Certainly. First of all, Wagner was a purely statutory interpretation case. There were no constitutional issues. And I do believe the legislature ultimately changed the statute to provide for jurisdiction in exactly those scenarios. But I do want to clarify just that whether you call it an act or conduct or whether you call it a result, the fact of the elements that the beliefs have to be created, the fraudulent information has to actually reach the recipient of the fraud. Whether you call it an act or you call it a result, it is an element, and our statute provides for jurisdiction in both cases. Thank you.
Thank you as well, Ms. Link. Rebuttal argument?
Thank you, Your Honor. The state initially makes the point that in the context of civil jurisdiction, the minimum context analysis is about personal jurisdiction rather than what we're talking about here, which is subject matter jurisdiction or criminal territorial jurisdiction. And I acknowledge that, that's a distinction, that we're, that's a difference. But I think that the same principles still apply, at least the root of it, which is this notion that there must be some degree of foreseeability that this state that this state's criminal laws are going to reach out and apply to these defendants that were never present within the state. The state also takes the position that there's really no cases applying any sort of constitutional limits in criminal cases, and I would take issue with that. I think there are a number of cases where there have been recognized that there are constitutional limitations on the reach of a state's criminal laws and its territorial jurisdiction.
Is this element of foreseeability enhanced by the world we live in now, where for me to make a reservation in a hotel in Des Moines, I'm talking to someone in Texas?
Yeah, I think the
even though I think I'm calling down here.
I think the importance of that increases in that world, because it is true that a statement that we make to a business can be internally transmitted through that business's internal processes to a location in a different state or a different jurisdiction, and it cannot be that just by them doing that, unilaterally doing that, that we then become subject to potential criminal prosecution and
But
application.
aren't we all so much more aware of it? We live in this world where electronically we're communicating with people all over the place.
Sure.
And the same with the practice of law. The internet has changed, as the internet and the whole world around us changed these concepts of what's fundamentally fair and what kind of knowledge you have to have.
So I think that's certainly true, that we are more aware that, that this occurs, that it's a more globalized world. But in terms of due process concerns, I think it has to be rooted in foreseeability that the particular jurisdiction statutes are going to apply, and that we subject ourselves to govern ourselves according to the requisites of that law. And I think it certainly increases the foreseeability, perhaps, that we're subjecting ourselves to federal criminal jurisdiction because of the reality that maybe it does cross state lines. But that doesn't mean that because the recipient of a communication internally processes it through 13 different states, that it becomes foreseeable to us that that's going to happen, and we're going to be subject to prosecution in all these additional states and be subject to their criminal laws as well.
What relevance, if any, to the territorial jurisdictional analysis is the fact that the victim is a Wisconsin insurance company that paid money out of Wisconsin, not Iowa?
So to the extent that there's a result element that is defined in the crime, and the state talks a bit about, that the jurisdictional statute talks both about conduct and result. It's important to note that the result has to be an element, not just, some effect or a result that occurs as a result of the conduct. So, for example, in the theft statute, the obtaining of funds is a necessary result. So the fact that the bank account was in Wisconsin bears on that and doesn't give Iowa jurisdiction, because that's where that element occurred. In terms of the state's position that in order to be deceived or defrauded, the victim has to receive the communication, I think it also has bearing in that context, that to the extent that that's the case, and that that's an element of the offense, the victim that received it is the Wisconsin insurance company and not the individual claims handler that was in Iowa. Again, I would point the court to the various cases cited in the defendant's brief that demonstrate that there are constitutional limitations and that apply if this foreseeability requirement rooted in the same concerns that minimum context has in the civil context to the criminal context, including the Kansas case, Palermo, the Ninth Circuit case. The Gayhart case out of Michigan also does so, and it talks about how the Second Circuit and the 11th Circuit have also applied this requirement in the criminal context, and McCormick out of Michigan as well. Thank you.
Ms. Reddy, thank you as well. Mr. Dusmer, did you need a minute or two to sum up on anything?
No, but I was going to help the court on page 58 of the appendix is the only place the area code 563 exists. Fortunately, it's at the top of page 4 and page 39. And there's a reference on page 106 of an 815 area code being identified as Wisconsin, 815 is in Illinois.
Thank you very much. The three consolidated cases, State versus Rimmer, Murphy, and Thomas, are now then submitted